Now, in my most recent video, that was one about all the Just Stop Oil people, and while I expressed my disapproval of their actions, I did say that, there are occasions when I think it is legitimate to break the law. But I thought, for the sake of all the viewers, and apparently the BSB, I should explain what I meant by that. So, unusually, made some notes. What I want to talk about are two defences that we call necessity and lawful excuse. And there is a little bit of an overlap there. But I'll give you an example. If I go around and just start smashing car windows, that's criminal damage, and obviously I commit an offence. But what if I come across a car parked and there's a dog sat there, and he's clearly like it's too hot and he's overheating, and I take the view that that dog is suffering, and I break the window. Do I commit an offence? Well, probably not. In fact, down in Devon and Cornwall, definitely not. The police have made it very clear that if you leave your dogs in cars and people break windows, they will take no action against the people who break the windows, but they will against the people who leave the dogs. So obviously I approve of that. But no, because although criminal damage is an offence, it was necessary for me to commit that offence to prevent a greater evil, as we say. And sometimes you get this thing where we call like lawful excuse. This is where, yes, you commit an offence, however, there is a defence to it. The classic example for a lawful excuse type thing is if you're out with a bladed article, more than 3 inches, then you commit the offence. However, if you can show, of course, a good reason for having it, like I've got a Stanley knife, but I'm a carpet fitter, well, that good reason amounts to a lawful excuse. But I want to give you an example from a real case about what the test is. So basically, my chap, he was one of my animal rights friends, associates, and he graffitied the Old Bailey about how we needed to address sort of animal rights and things. So obviously he was prosecuted for that, and he was convicted. The funny thing is, when he was convicted, this was at the other court, this was the old Thames Mags, he also graffitied Thames Mags, and I've got a great photograph where the police are stood there, they didn't quite realise what was happening, and then they do, and he sort of gets dragged off, and you see the sort of paint line disappearing. It's a bit like in Monty Python with the Castle Arg thing. But anyway, I was trying to do the appeal on that. Now, rather helpfully, because obviously, the court sussed we were going to run necessity, because they put that in the grounds of appeal. The judge who was hearing the appeal had also dealt with all the Extinction Rebellion people. I mean, technically this guy was what used to be called Animal Rebellion, now Animal Rising. And he sent me, he said, well, this is my ruling from the Extinction Rebellion cases, so, just to assist you. And it basically said, not a chance, matey boy. So I had to try and run a slightly different thing. But the test for necessity, it's a 4-part test. It's from a case called Jones. He was somebody who refused to serve in Iraq. So he was like disobeying what is, an order. But his argument was, well, even if that's a lawful order, which I disagree with, I am allowed to disobey it because, it's to prevent a greater evil. I don't think we should be in Iraq. But the test is this. Well, first of all, you commit the offence to prevent a, quote, greater evil. Now, that evil does not have to be in itself unlawful. So it's not, committing one crime to prevent another crime. You can say, well, actually, yeah, what I am trying to stop is perfectly lawful. I just still think it is evil. And it's worse than what I did. Also, it doesn't have to prevent something within this jurisdiction. So you can do something, even if it's happening abroad. If you say, well, my actions here will prevent that, or may prevent that, well, that's the first limb of the test. You also have to show that you have a responsibility to, of course, the victims of the greater evil. So the argument here would be, in that case, it was like, does a British squaddy owe any sort of duty of care to the people in Iraq? I suppose the climate change people would say, well, yes, we owe duty of care to humanity generally, or the planet, because you get all these people saying about personhood for landscapes and personhood for nature. In other words, you treat nature as if it were a living entity itself. I'll get very much into animism. But yeah, you've got to sort of say, well, I owe a responsibility to these people. The key thing is, and this is what catches a lot of people out, your actions have to be proportionate and reasonable. And that's where it's sort of, well, hang on a second, if you go completely over the top, I think it's a greater evil that people speed through my village at more than 20 miles an hour, so therefore I'm going to start putting some claymores down. That arguably would be disproportionate, but please stop speeding through our village. And you also have to have the honest belief in all this, and that's what drove you to act. So say, for instance, there was a case where it could be argued that criminal damage was all justified to prevent something, or blocking an aeroplane was, that was delivering something was all justified. If you just did it for the laugh, you don't really care about the cause, then you'd fail on that limb as well. It doesn't have to succeed, okay? To give another example, this is, a very common necessity case. You need to get somebody to hospital very, very quickly. They're having a heart attack. The ambulance can't get there quick enough, but nobody's sober enough to drive. So you go, well, I'm over the limit, but I'm going to drive to the hospital. Now, that can and has been shown to be, people have succeeded with the necessity defence on, yes, I was over the limit, but I had to get somebody to the hospital. Now, the mere fact that, if the person actually does pass away from a heart attack, or say, for instance, it's just, there's negligent medical treatment, it doesn't matter, okay? So it doesn't matter if your actions will ultimately be successful. I mean, effectively, this law, it protects attempts as well. It also doesn't matter if you had alternative options. For instance, I come across the car with the hot dog in it. Now, theoretically, I could just call a locksmith, couldn't I? And if they can get there really quickly, then they can get the dog out without damaging the car. But it doesn't matter. It's like, no, I just chose this option out of many legitimate options. Now, whether something, this is where we get really complicated in court cases where people say, I'm not allowed to present the defence, because ultimately, when it's a jury trial or magistrates, the jury are the ultimate arbiters of fact. They get to decide, it's entirely up to them whether they find, the facts of the case. And the judge applies the law. Now, what's been happening in these particular cases is whether something actually does amount to necessity, a legal test or a factual test. And this is where it can get a little bit confusing. I mean, in the Hallam case, the CPS, they put forward an admissions and they said, we accept that climate change is real and is a massive danger. We just say that their actions were disproportionate. They fail on the third limb of the Jones test, because what they were trying to do, it was completely disproportionate for the, quote, evil that they were trying to address. Because, as we've heard, it caused absolute chaos, it caused accidents, people missed sort of medical appointments for very, serious life-threatening illnesses and all that sort of thing. So, but in the end, the judge left that to the jury. He said, okay, you know what, I'm going to leave whether or not this actually factually amounts to necessity. I'm going to leave it to you. Now, necessity is a defence to all crimes, except the M word. I'm sure YouTube won't mind me saying that. But this happened, it was very common during the Troubles, where, of course, freedom fighters, however you want to call it, from either side, they would basically commandeer cars, especially taxis, and say, right, drive us to this address, where they would be carrying out a hit. And technically, the driver then was an accessory to the M word, because it's like, yeah, but for you, they wouldn't have been able to get there. Now, the fact that they said they would take you out, the law says, well, unfortunately, you're not allowed to put your life before somebody else's. Now, I was going to go and film this down in Falmouth, because there's a key case, just check that's still recording, yeah. The key case, and I'm going to do a big video about this, because it's a case called Crown and Dudley and Stevens, and it's about some people who got shipwrecked and, in a lifeboat for 38 days, and they drew straws, the cabin boy lost, and they ate him. And this was a bit of a cause célèbre at the time, because that was, quote, the rule of the sea. Everybody accepted that that's what you did. But that actually ended up in court. And that came back and they said, well, actually, no, Necessity is not a defence to the M word. You should sacrifice yourself, and it doesn't really matter if your sacrifice, taking out one person saves lots of lives. Now, this cropped up after 9/11, because it's like, can you shoot down an airliner to stop it crashing in and taking out even more people? Well, actually, under UK law, well, English and Welsh law, no, you can't. However, there was a case, remember the Townsend Torreson Spirit of Free Enterprise? In that case, when they were evacuating the ship, somebody froze on the ladder. They just wouldn't move, and they were trying to get everybody out very quickly. So they actually pulled the person off the ladder and just pushed them, and they fell to their D word. However, the CPS said it would not be in the public interest to prosecute, because there's that two-part test. Is there a realistic prospect of conviction? Well, in that case, yes, because it was admitted that they'd intentionally done something that unalived somebody, to use the buzzword. However, in the circumstances, had they not done that, loads of other people would have drowned. So it wasn't in the public interest to prosecute. And the other thing here is, it's a common argument that, well, if we allow people to do this for one thing, there may be some meritorious claims and defences, but loads of people are going to bring unmeritorious ones. Lots of people are going to, people are just going to try this on every time. But there is actually a case that says the floodgates argument is not a legitimate argument. So you can't say, just because some people may abuse this law, you shouldn't allow anybody to use it. So, that crops up in quite a few situations, that where you say, well, hang on, is this a slippery slope? The law actually rejects that argument and says, no, the floodgates argument, the mere fact this might bring lots of cases, that doesn't really matter. I'll probably do more on this, because necessity also crops up a lot with use of force, which is sort of one of my alleged specialities in terms of defending people. Although, ironically, I did a course last weekend that was like a sort of how to, with some SF guys, and how to do things and when to take people out. But because I'd actually not done the threat assessment module, they assumed that I wouldn't need to. I actually failed the course because I took out a couple of innocent civvies. Although also I did walk past somebody who was actually pointing a Glock right at our principal. So I think that was a very valid reason to fail. But yeah, so there you go. I think I've covered everything. Got my notes. Yeah, 4-part test, necessary, lawful excuse, all that sort of thing. But like I say, I will do more about the cannibal case because it's really absolutely fascinating, but I'll try and film it in Falmouth at all the original locations where it all actually happened. I mean, not obviously out at sea where they ate the guy, but where they were first interviewed, where they spent the night in the cells, where the court was and all that sort of thing. So there you go. Where am I today? I'm just back up at Pentyre again. Although I've come right to the edge of the headland, and you remember, Pentyre means headland in Celtic. And I'm not going to lie to you, this is a really scary place to be, because if I move about 3 feet that way, there's nothing but a 45-degree slope, and then it just suddenly drops off and drops about 150 feet. So I'm going to stop filming now and very delicately pack up and try not to fall back into the sea. Oh! And if you did enjoy this and found it vaguely useful, vaguely accurate, vaguely interesting, informative and all that sort of thing, please consider liking, sharing, subscribing. I mean, I'm changing now because I never used to be bothered about this, but I'm about 100 subscribers off 25,000 and all of a sudden just seeing that number is like, ooh, wow.